As the court pleases, I'm Isabel Ellis, acting on behalf of the applicants in this matter.
May it please the court, Deputy Chief Justice Ian Curry for the respondent.
Thank you, Advocate Curry. Ms. Ellis?
As the court pleases. On a point of housekeeping, the applicants have also asked for condonation for the late filing of the application for leave to appeal. In the event that the court should find that
It is unopposed.
It's unopposed. So if the court would grant leave to appeal, we would also request the court to condone the one-day belated filing of the application for leave to appeal. The crux of this matter concerns two questions. The one is the proper interpretation of what is a just and equitable remedy in terms of section 1721B of the Constitution. And the second question is the arguable point of law of general public importance, which is the two conflicting lines of judgments in the Supreme Court of Appeal. The one line of judgment supports the arguments made by the applicants on what is the proper interpretation of just and equitable relief, and the second supports the respondent's argument on what is just and equitable relief. On that point, the conflicting judgments, and what I propose to do is to highlight the conflicts in the two lines of judgments in the Supreme Court of Appeal in order to demonstrate that the line of judgment supporting the applicant's relief, which they seek in this appeal, is the correct interpretation as opposed to the interpretation proffered by the respondents. So the argument is a dual argument on the interpretation of section 1721B. So the first problem with the interpretation in the judgment of the Supreme Court of Appeal, Special Investigating Unit versus Pumela Property, and I will refer to it as the Pumela judgment, is that the Pumela judgment severely criticized, and not only criticized, but decided not to follow this court's findings in All Pay 2, if I may refer to the All Pay judgment as All Pay 2. That is All Pay with the citation 2014 for SA 179. It's number 3 in the list of authorities of the applicants. The most important findings made by All Pay 2 is in determining what is just and equitable in terms of section 172. There are two principles. The first principle is the correction principle, and that derives specifically from section 1721B of the Constitution, where the court must correct the defect, and that is in terms of section 1721B2 of the Constitution. The second principle is, and that is the principle which the applicant submits, presented the biggest difficulties and the reason why there are two conflicting judgments or lines of judgments in the Supreme Court of Appeal. The second principle is the no profit, no loss principle. What All Pay said is that the basic principle is that a party is not allowed to benefit from an unlawful contract. Now, if one have proper regard to Section 172 of the Constitution, 172(1) of the Constitution, it is clear that a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And if regard is had to Section 172(1)(b), the court then may make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity. But I want to stop there, because the basic principle in terms of Section 172(1)(a and the effect of such an order is that the law or the conduct is declared invalid, effectively void ab initio. So it is automatically declared invalid from the start. So that is the starting point. Now, in terms of which the applicants say is the controlling law, contractual principles. If a contract is declared unlawful, it is void ab initio and it is unenforceable. So that is the starting point. In terms of, and it is specifically dealt with in a footnote 47 in the All-Pay-2 decision, where the court describes it in the following terms: the dissolution of a contract, and that also includes where a contract is declared unlawful. So the dissolution of a contract creates reciprocal obligations seeking to ensure that neither contracting party unduly benefits from what has already been performed under a contract that no longer exists. So the de facto position is, if the contract is declared unlawful, it is void ab initio, and neither party can rely on any contractual remedies or obligations in terms of the contract. So this is now how it works in private law, in contract law. So this is evidenced in, the footnote continues, this is evidenced in cases of rescission or cancellation of a contract where a party claiming restitution must usually tender the return of what she received during the contract's existence, or, if return is not possible, explain the reasons for impossibility. So the principle is that restitution must take place. Each party who have performed under the unlawful contract must return what they have performed, because no one can benefit under an unlawful contract. And this principle has also been confirmed in the All-Pay-2 decision as also applicable in respect of public law and public law principles, which must be taken into account when devising a just and equitable remedy. So, in the event, and that is where the private law, or if I can call it the private contractual principles, come into play. This is confirmed also by the principle, and it's in the applicant's heads of argument, referred to as the Wilkin versus Collar rule. Now that is a defense. Restitution in the private contract law is claimed or may be claimed by the condictio ob turpin vel justum causam, and that is on page 26 of my heads of argument and referred to in paragraph 32.7. However, the Wilkin versus Scholar rule was accepted as a valid defense. The causum condictio obturpum vel justum causum is a recognized enrichment claim. So, in the event that a party has performed, whether in whole or in part, in terms of an illegal contract, the performance may be reclaimed by that enrichment action, the condictio obturpum. However, a party may proffer the defense or raise the defense of the Wilkin versus Scholar rule, which in essence is the following. So if both parties to an invalid agreement has performed in full, neither party can recover his or her performance purely on the basis that the agreement was invalid, provided that where the purpose of the transaction is prohibited in law, that defense is not available. In other words, when it concerns an unlawful contract, declared unlawful, and the applicants submit that the same principle applies when determining a just and equitable remedy. In this instance, if the contract has been declared unlawful, so prohibited in law, that defense is not available. So the parties cannot retain what they have performed. That is what the Wilkin versus Scholar rule, the defense is. But if the contract is a contract that has been declared unlawful, that defense is not available. So the party cannot retain, or parties cannot retain what they have performed. So in the Pumelo matter, that is the matter of Special Investigating Unit versus Pumelo Property Investments. In that matter, the Supreme Court of Appeal decided that they are not going to follow the two principles enunciated in All Pay 2. So that is the corrective principle as well as the no loss, no profit principle. In fact, the court in Pumelo specifically said that it's not following the no profit, no loss principle. And they also criticized their own decision in Central Energy Fund, SOC Limited, and another versus Venus Rays Trade. So, in the Central Energy Fund, the court, in one of the findings, also referred to the principle of restitution that must take place when a contract or a tender has been declared unconstitutional and invalid, confirming the principle that the status quo ante must be restored. So the no loss, no principle allows a party to retain or to be compensated purely for services rendered, no profit included. So in the event, and there's a distinction also between the two different parties, if a tenderer whose tender has been declared, that's now the private party contracting with the organ of state, if the private entity is found to be an innocent tenderer, not complicit in any of the irregularities during the procurement process, that innocent party is entitled to claim expenses without profits, that's the no profit, no loss principle, to be compensated for services actually rendered. Or, as the applicants would have this court to correct the Supreme Court of Appeal's order in the Zeal matter as out-of-pocket expenses. And that confirms with the principle, no profit, no loss. So it does not include profit. In the Pumelo matter, the court specifically denied that the matter in all by 2 made the finding or held that cash paymaster is not entitled to retain all the benefits, including the profits, after the contract was extended for a further 12 months. We respectfully submit that that is most definitely not the case. The all by 2 matter, and if I recall correctly, earlier this year, this court was again tasked with hearing the matter on determining the profits that cash paymaster, who is now in liquidation, must account for. The reason being simply that when a party contracts or tenders for the state, it steps into the shoes of that organ of state fulfilling a public function, and therefore it must be held accountable to the public for the funds expended. In the event that the contract is declared constitutionally invalid, it follows logically that the public funds, the profits or the undue benefits in terms of that contract must be repaid for the benefit of the public, because it comes out of the public purse. So that's in the public interest. That is also the reason why the Pumelo judgment, the order made at the end, effectively told the innocent tenderer that you can retain all the benefits derived from an unlawful, unconstitutional contract, because the contract has already expired, without having to repay the undue benefits, which are the profits made from that contract. So we say that that in effect provides an innocent tenderer with more rights in the sense that the Wilkin versus Scholar rule is therefore made applicable to unlawful contracts in the public law, but not in private law. We say that cannot be correct. That was not the intention of all pay and the intention of this court when discussing the 2 principles that apply in respect of the just and equitable remedy in the circumstances of this matter. In the second line of judgments by the Supreme Court of Appeal, which we say must be followed in this instance in order to correct the order, the first one is the Central Energy Fund and another versus Venus Rise trade. In that matter, the court correctly, in our view, applied the 2 principles. The no loss, no profit, no loss principle was correctly applied. The contract was not reinstated or the invalidity was not suspended in order to provide the innocent tenderer with accrued contractual benefits or obligations or remedies or any other contractual remedy allowing that tenderer to claim profits as well. And the order made by the court in that instance is akin to the order made in the Bravo Span matter, that is the matter of the Greater Tsandine Municipality versus Bravo Span, the order made by the Supreme Court of Appeal, and I'm referring to the Supreme Court of Appeal judgment in that instance. Similarly, although the facts and the the historical sequence of events leading up to the court making the order is not on par with the facts in this matter. The order which the court made is a just and equitable remedy premised on the two principles enunciated by this court in All by Two, especially the no profit, no loss principle. So again, the contract was not reinstated or the invalidity of the contract was not suspended. On that note, it is very important to emphasize the fact that the respondent emphasizes that they were an innocent tenderer in the process, not complicit, and wherefore the Gijima rider, as they call it, that suspends the invalidity of the unlawful contract applies in that instance. However, that cannot be the case. The courts have, over the years, emphasized that there is no one remedy fits all when it comes to just and equitable remedy. So what must be taken into account is the facts of the matter, the constitutional principles, and then the controlling law. I've already addressed this court on the controlling law principles and why we say that the order made by the Supreme Court of Appeal followed the findings and the decisions in Pumelu, which is incorrect, and that the reasoning and the findings made by the Supreme Court of Appeal is the Greater Tzaneen Municipality versus Bravo Span and preceded by the Central Energy Fund. So that is the controlling law. However, when it comes to the fact that the Supreme Court of Appeal failed to take into account, my learned friend in the heads of argument say, but yes, those facts were not put before the court. It was before the court. It was part and parcel of the record. The court only concentrate on the fact that the respondent was an innocent tenderer in that the respondent was not complicit in the irregularities. That, with respect, is not how a just and equitable remedy must be determined, and that is also not how Section 172(1) must be interpreted. So, some of the facts that are pertinent is, one, there was no undue delay in the applicants launching the state self-review. In fact, it was launched less than 5 months after the decision was taken or the award of the tender. Secondly, the applicants did not mislead or entice or allowed the respondent to continue to provide services without paying the respondent. So that was a factor which had to be taken into account in all the other matters where the suspension of the invalid contract was ordered by the court. So there was no enticement, or the applicants also did not allow or requested the respondent to continue to provide the services unabated. That is not what happened. On the respondent's own version, the respondents terminated the contract or the services rendered under the contract after 2.5 months, less than 2.5 months, from the 1st of June 2015 until 12 August 2015 on their own version, and they never ever offered to resume the services to applicants. They never. So, there was no continued services provided by the respondent under the unlawful tender, and what the respondent did after that is to claim specific performance, which is a typical contractual remedy, payment under the contract of 3 invoices that were rendered in terms of the contract price that was declared invalid and unconstitutional. So the respondents resisted payment under the 3 invoices, which we would submit they were entitled to do by launching the state self-review less than 5.5 months after the decision to award the tender was taken. So there was no undue delay in the launch of the review by the respondents. We would submit that's a factor which the court failed to take. Those are the main facts which the court failed to take into account. In any event, the courts have also, over the years, conclude that the undue delay in launching a state self-review is part and parcel of the factors that need to be taken account when the court must decide on whether to suspend an invalid contract as part of the just and equitable remedies. And we submit that that is not the case here. The Supreme Court of Appeal did not even refer to that as a fact. In fact, the Supreme Court of Appeal did not refer to any of the factors listed in the heads of argument that should be taken into account, apart from the legal principles which were incorrectly applied. So that, in short, is the summary of the case made out by the applicants, and we would submit that it raises a constitutional issue in terms of section 1673B1, read with section 1677, and that this court should, in the interest of justice, grant the applicants leave to appeal and correct the Supreme Court of Appeal's order, which is bad in law. If the order in the Supreme Court of Appeal in this matter stands, it supports the incorrect judgment that was handed down in the Pumelu matter, and I refer to 3 judgments or 3 decisions. I don't know how to refer to the special tribunals due to the fact that this court has said that they are not a court. However, the judgments are judgments by the special tribunal, and I refer in paragraph 41 and footnote 86 of the heads of argument to specifically 3 decisions, judgments by the special tribunal where the SIU, the Special Investigating Unit, who, by the way, their main aim is to recoup undue benefits, specifically as a result of unconstitutional, unlawful and invalid tenders. That's the main aim. And the undue benefits are normally profits. So the no profit, no loss principle is specifically part and parcel of the workings of the SIU and the special tribunal. These cases demonstrate the difficulty that the special tribunal and the SIU have with the Pumelu judgment. If that judgment stands, and it's only this court that can make a finding that the reasoning in the Pumelu judgment is not to be profit, but that the reasoning in the Bravospan, the Greater Tsenin Municipality, and the Central Energy Fund is to be followed. And if the finding is made by this court, it follows that the court should also then correct the incorrect order that was made in paragraph 2.2 of the Supreme Court of Appeals order. I also submit in closing that the reasons why the applicants do not ask for costs follows that the principle in obtaining a correct legal order is more important than appealing the cost order, and that is also the basis upon which no cost is sought against the respondent in this matter, as the court pleases.
Thank you, Ms. Ellis. Just to make sure I understand you clearly, you're saying until Pomela, all pay was followed by the courts. And by that you mean what you say, no loss, no profit rule was consistently applied until Pomela.
Indeed, and that is clear from the line of judgments, especially the latest judgments by the Supreme Court of Appeal in the Central Energy Fund, which was confirmed in the Greater Tsenin Municipality versus Bravospan, indeed.
Thank you very much.
Ms. Ellis, just one question. In Kijima, the contract was extended, and the delay on the part of the state organ was about 22 months. And maybe that is why the court made the order that it made, because Kijima carried on performing and rendering the service. You are saying in this matter, Zeal performed for about 2 months, basically.
2.5,
Two and a
yes.
half. And if one upholds the order of the SCA, Zeal will end up claiming in terms of the contract when the applicant, in fact, actually acted promptly during the self-review process.
Yes, Justice Mhlantla, if I may just add on that point. One of the factors that the Supreme Court of Appeal also did not take into account is that in order to mitigate the damages to be suffered by military veterans in respect of health and wellness services, the applicants had to resort to the MOU that the Department of Military Veterans had concluded with the Department of Defense in order to allow military veterans access to health care and wellness. Under that MOU, the Department of Military Veterans, of course, had to pay the Department of Defense for the services rendered by the various military health facilities in terms of the defense and in terms of the MOU. So on that note, applicants had to expend monies in order to ensure that there is a continuing provision of public services, healthcare services to the military veterans.
Yes.
Yes.
In your notice of motion, in this court, para 3, that is the order that you seek, where you say that if we are with you, we should replace the order of the SCA with an order that says it is declared that Zeal Health is entitled to compensation for its out-of-pocket expenses. And then you say, alternatively, I think from your argument, you do say, you refer us to the Bravospan SCA order. I would like now you to explain.
Yes,
There's no difference between.
well, the difference, Justice Mhlantla, if I may, the out-of-pocket expenses is more in line with the order that was given by the Supreme Court of Appeal in the Central Energy Fund,
Yes.
SOC Limited. Although out-of-pocket expenses presuppose expenses that will cover your supposed losses So under the enrichment or restitution principle, we will compensate you for your actual services rendered without any profit margin. That is the purpose of the order, but it's a combination of what the court ordered in Buffalo City, I beg your pardon, in the Greater Tanin municipality and the Central Energy Fund. However, the order does not include a reinstatement or a suspension of the invalidity of the contract. Yes.
My understanding of the Bravo Span order, that is para 2 of the judgment of the order, it says plaintiff is entitled to compensation for the services rendered to the defendant during the period November to a certain date. And if you say maybe that also would be fine, then if one takes that to this case, one would then say Zeal is entitled to compensation for the services rendered from 1 June to 12 August 2015.
Indeed.
Will that be fine?
Indeed. And that is also what we ask, if I recall correctly, in the notice of motion.
It says out-of-pocket expenses. I'm not sure if that's the same thing. So,
It is exactly the same thing.
the same thing.
Indeed, indeed. Exactly the same thing as to be compensated for services actually rendered without any profit margin. So no profit, no loss.
Okay, thank you.
Can I just follow up on that one? So what you seek from this court is an order that you be paid for those months, alluded to my colleague, only in respect of the expenses incurred without any profits accruing for those 2 months.
Indeed, Justice Mayi.
Now, I checked the record, and you may correct me if I'm wrong, but it seems to me that in this matter, we don't have on the record the service level agreement or the tender from which we can discern what the general conditions of the agreement were, of contract were. Or did I miss it in the record?
No, Justice Majid, but there was no service level agreement concluded.
I see.
And the terms of reference in the tender document was also not regular.
Yes, that's unfortunate because, well, you're not asking for it, but just postulating a scenario where you would seek in terms of the general conditions of the contract or of the tender, for example, compensation beyond the mere 2 months, that would have been problematic, but I suppose that doesn't come into play at all.
No.
Because that's all you ask for. Yes, I wanted to check on that part of the record. Yeah, thank you. Thank you, DCJ.
Thank you, Mr. Ellis. I'm just trying to establish your understanding of paragraph 2 of the SCA order. As I read it, it says the order of constitution and invalidity does not have the effect of divesting Zeal Health of any rights to which it would have been entitled under the contract referred to in paragraph 1, but for the declaration of invalidity. As I read it, all of their rights, irrespective of the invalidity of the contract, are reserved in full.
Yes, it's as if the contract is not unconstitutional and unlawful.
So on this provision, would they be entitled to submit an invoice, let's say, for the period beyond the 12th of August?
They have. The third invoice, Justice Collipin, is not only for the time period of 1 to 12 August, it's in fact for the whole month.
But my question is, would they be entitled to do so for the full duration of the contract based on this order?
No, because the accrued contractual rights, which...
This order doesn't speak about the accrued contractual rights.
No, it doesn't. But the respondent accepted that that order provides them with their accrued contractual rights, and their understanding of their accrued contractual rights is to claim payment of the 3 invoices under the contract before its declaration of invalidity, And together with that, the lost profit, which they claimed in the action which they already instituted in March of 2021.
Good. Then my next question is this based on either the out-of-pocket expenses or being compensated for the services they rendered, which could be different. But it arises out of this, is that in the agreement that was entered into between the parties, they agreed on a capitation model, which said, you're entitled to invoice us for the number of military veterans set at the potentiality, let's say, of those we may need to provide services for. That was set at 16,000, but it was brought down to 14,636. That model was not based on the number of persons actually seen.
Not at all.
Right.
No,
Right.
yeah.
So in the first month, there was approximately 1,155 people seen.
Indeed, and that is on the respondent's own version.
Right. Well, that's also from your health and wellness report, correct? But the model allowed for invoicing for 14,346.
Yes, that was a number that the respondents,
So that came to about 5.2 million. But if one did it on 1155, which is the actual services provided at 365 rands per person, that would come to 422,000 rands, correct?
yes.
Now, my question to you is this. If the contract has been set aside as invalid, then what basis would be used to quantify these services rendered? Would it be permissible to use part of it, which is 365 rands, 0.48, which comes from the contract? Or is it permissible to use the capitation model and say, well, that's what they had to have in place during those 2.5 months to service the 14,000 veterans, and if they serviced 1,000, which is less than 10%, then they're entitled to that. And I ask this question in the context that all pay says that where you derive a benefit from an unlawful contract, then the question of public scrutiny is important. The public is entitled to know, well, what are you paying for? In this case, would public scrutiny lend itself to different answers, or would it be consistent with public scrutiny to say, well, they're entitled to payment for 14,000 veterans, even if they saw less than 10% of that, because that's what you agreed upon.
No, but Justice Colopin, on that note, the capitated fee was part and parcel of the reasons why the contract was declared constitutionally invalid. Because the purpose by the Department of Military Veterans was always to contract on a basis of fee for services rendered. And that was also the basis upon which the interim contract.
Well, the capitation fee pushed the contract figure to be on, but was that the reason why it was declared invalid? Was it not simply that you didn't have the funds for this?
Yes, but that,
What kind of model you choose is not for the court to decide. If you decide to choose a capitation model, that's fine. But if you don't have the funds for it, well, that's a different matter.
yes,
It wasn't based on the capitation model, but rather on the deficiency in a budget to meet the contract, correct?
that was also part, the infringement of Section 38 of the Public Finance Management Act was also part, but the fee for services later on after and during the minutes of the SCSS department's meetings, it panned out that the intention was never to tender on a capitated fee basis, but on a fee for service basis.
Well, you see, I ask these questions, Ms. Ellis, because let's assume if this court is minded to interfere with the order of the SCA, and that's not a foregone conclusion. it should do so in providing a just and equitable remedy if it's different from that which the SA provided, that provides sufficient certainty. We've had experiences where cases keep coming back.
Indeed.
And what is that certainty that you think, well, certainly that you seek? Would it be in order that they be paid for services provided? But what does that exactly mean, and at what quantification?
Well, for services provided in the event that they can prove that they expended, because Justice Colopin, you must also remember that on the respondent's own version in the founding affidavit, they say that they already from the 30th of July, 31st of July, when they were not paid the first invoice under the contract, the first invoice of 5 million plus, already informed their service providers, the doctors, to refuse to accept military veterans and provide services to them, and instead insist on them paying cash. So that is also a factor that needs to be taken into account. For out-of-pocket expenses, the respondent must prove that it indeed, and those health reports were compiled by the respondent. So on the respondent's version, they on their own version only rendered services during those 2 or 3 months, if one have regard to the fact that they rendered a health report for the entire month of August, as well as a invoice for that month. If one has regard to the information provided by the respondent in those documents, they most definitely did not render services. And did they actually compensate the service provider for those services, or are there instances where the military veteran had to pay cash for that services? So it's for the respondent to prove what the out-of-pocket expenses was in rendering the services during that period. And that the High Court can determine. But to simply say that under the circumstances, the capitated fee invoices must be accepted as payment for services rendered is, with all due respect, not a fair and equitable remedy. Well, because it was part and parcel of the reasons why the department did not pay the first invoice in the first instance.
Subject to what Mr. Curry says, it might go beyond compensating somebody for the services they provided, which is what certainly the jurisprudence currently stands at, not so. You compensate somebody for services provided even under an invalid contract on the best case scenario. But to compensate somebody for services not provided goes beyond that. That's fine, Mr. Curry might deal with it. Thank you.
Sorry, I have one more question, but I have just a question on this debate with Justice Colopin. If there's no service level agreement before us or tender conditions, what then regulates this order of the SCA? What's the relationship then? How do we get to the fees? I mean, if you look at volume 1, page 19 of the record, perhaps you should go there. I'll give you a minute or two. Paragraph 28. There's a reference there to the price on the contract form that's signed by the DG, 198 million rand, and what it represents and how it's broken down for the year 1, 2, and 3, and the grand total at 28.4. So where are we then if there is no service level agreement or conditions of contract before us in this case?
But Justice Majid, if I understand your question correctly, it now refers, it now conflates again the principles of, are we going to refer to the contract in order to determine a just and equitable remedy? So that is what the Supreme Court did. It says, reinstate the contract. the applicants say no. There's no reason to reinstate the contract. The no profit, no loss principle clearly stipulates that the benefit that the respondent can derive from this unlawful contract is to be compensated for the actual expenses without any profits. So then the terms of any possible service level agreement or the terms of the unlawful contract does not come into play in that instance. It is simple justice between man and man.
You see, I'm just concerned that we might only have half a picture here, but let me ask you this, the question that I do have, that I omitted to ask earlier. I wasn't in the case, but I think this court earlier this year in Ikapa mining, I was recused in that matter. In Ikapa mining held that when a court makes a just and equitable order in terms of Section 172, it is exercising it through discretion.
Indeed.
Now, accepting then that the SCA was exercising it through discretion, you have to then show that it was within the narrow confines of interference on appeal. You have to show what was unjudicial in exercising that discretion. What is it?
Yeah, with all due respect, this court has also held that in order to determine a just and equitable remedy, there's no one remedy fits all. So it must be determined in accordance with the facts, the constitutional principles, and the controlling law. And I've already addressed this court on the controlling law principles and why the applicants say that that was negated or ignored by the Supreme Court of Appeal. So with all due respect, in light of the facts, the constitutional principles, and the controlling law, the order made by the Supreme Court of Appeal cannot be held as a just and equitable remedy on the facts and in law. It simply can't.
Now, there are certain factors that a court will consider when it determines a just and equitable remedy. Now, I give you these three factors and ask what is unjust and inequitable about the SCA remedy. First, you accept that Zeal is a completely innocent party here.
I am not prepared to make that contention. It is an innocent tenderer in as far as the applicants could not prove any fraud or participation in the irregularities in the tender process.
It's either one or the other. You can't straddle two chairs.
No, it's an innocent tenderer, yes.
Okay, now we've established that. You accept that they acted in good faith in this tender and exercising the, performing in the contract? There was no mala fides here.
No, but Justice
Nothing
Madrid,
underhand.
no, there was a couple of grounds upon which the review was premised where there were questionable issues that the court also held in order to find, the High Court now also held to find, and the Supreme Court of Appeal did not interfere with that decision to declare
Well, okay,
the entire process.
I'm prepared to live with innocence only. It's an innocent tenderer, so forget about good faith. Now, the problem lay with the state, with the department, didn't it? Because you came on a self-review. The budget wasn't there, and yet you proceeded. That's where the difficulty lay. You accept that? That's why you came on a self-review.
No, we accept that.
Okay. Second, that's the first factor. Innocent tenderer, department didn't do their homework. Second factor, the reality of this case is that in fact and indeed, Zeal rendered services. That's also accepted.
Indeed, but not to the value as they claimed in the 3 invoices which they tendered,
Right.
coupled with the action for lost profits which they instituted and intend to proceed with. Most definitely not.
Then thirdly, is this not an all-pay scenario where CPS was allowed to continue with this tender so as not to disrupt services in the public interest? And is this not a matter akin to that, where Zeal really had to continue with services because you ended up paying millions more to the military hospitals, also inaccessible? A department that doesn't have the budget spends millions more paying for inaccessible military hospital treatment for the veterans.
Oh, Justice Majid, that is an allegation made by the respondent. It's not on the papers that the department paid millions more for the services rendered under the MOU. But that is also not a reason to declare the Supreme Court of Appeal's order as just and equitable. Not on the facts, not on the constitutional principles, and not on the controlling law.
All I can say is I hear you. Thank you, DC.
Ms. Ellis, how exactly do you understand the SCA order? Do you understand it as preserving the Zeal's contractual rights for the full contractual period, or just for that 2.5 months?
No, for the full period. Justice Nichols, that is why Zeal Health that was Zeal Health's intent in the High Court, the intent in the Supreme Court of Appeal. They wanted the Supreme Court of Appeal to overturn the High Court's finding of constitutional invalidity in order to preserve the contract, the lawfulness of the contract, in order to exercise their contractual rights, so their full contractual rights. So there was no intent ever by Zeal Health to preserve the principle of no profit, no loss.
No,
none.
I'm not talking about no profit, no
Yes.
loss. I'm more talking about the period. Are you suggesting that that order preserved the contractual rights for the full 3-year period?
For the full 3-year period, yes.
But how do you marry that with paragraphs 24 and 25 of the judgment?
Justice Nichols, yes, that is part and parcel of the problem, that the findings that the Supreme Court of Appeal made in the judgment contradicts the order that they, yes.
So is that the fundamental problem, that the order contradicts the findings of the judgment? Because the finding of the judgment seems to indicate that Zeal had rendered services in terms of that contract. And in 25, they were to pursue payment for services provided, not for services that weren't provided down the line.
Indeed, but that is the problem, because effect must be given to the order. And if the order is interpreted, that order is for the full 3-year term of the contract. It reinstates the contract as if it was not unlawful or invalid. And Justice Nichols, you must also recall that the Supreme Court of Appeal was fully aware of the fact that that Zeal has instituted an action for lost profits for the full contract price.
Well, that was for another court to decide. Before, it was just the contractual rights, to what extent they should be reinstated.
Yes, but the monetary claim, or the claim by Zeal Health in front of the Supreme Court of Appeal, was for the 3 invoices rendered for June, July, August, and to proceed with their action for the lost profits already instituted in March 2021. So that is for the full contract price.
Where is it to proceed for the lost profits for the 3 years?
No, the Supreme Court of Appeal just refers to the fact that Zeal has instituted an action. But they don't refer to the fact that it is for the full contract price less the 3 invoices. So they just refer to it in passing.
So you would have been satisfied if this order had said, as the SCA did in Bravospan, saying it is declared that the plaintiff is entitled to compensation for services rendered for this period to that period.
Indeed, without any profit
No,
profit
you didn't
margin.
say without any profit.
Yeah, but-
In Bravospan. I'm asking you if you'd be prepared to accept the order in Bravospan, a similar order, but just with the correct periods.
Indeed, yes. The applicants will suffice with that order without reinstatement of the invalid contract, unlawful contract,
But
yes.
you would be happy with the order saying it is directed that the plaintiff is entitled to compensation for services rendered to the defendant during the period
1 June 2015 to 12 August 2015.
to 12
Indeed.
August 2015 for services rendered as a just and equitable remedy under.
Indeed.
Now, and you say compensation only means out-of-pocket expenses. It can't mean anything else.
It cannot, no.
And my last question is, would it make any difference if, let's assume, as you say, if Zeal did know about the invalidity. So it was complicit in some way, but nonetheless it rendered the services. What compensation would it be entitled then?
No, well, then the case law is clear. If there is any impropriety or any fraud unravels all.
Right.
No profit, no losses, compensation. Must be prepared to walk away.
So, in conclusion, I think that what you're saying is we as a court must decide what compensation means in these circumstances. Compensation for services rendered between 1 June and 12 August means.
In the event that out-of-pocket expenses and services or compensation for services rendered is not compatible.
I don't understand. No.
Well, if services actually rendered does not mean the same as out-of-pocket
Oh, I see.
expenses.
Not the same. All right.
Thank you, Justice Nichols.
There is an action or a matter that is stayed. What is the status of that matter? One, let me finish. In the event that we are with you on this point, right? In other words, if we are to upset the judgment of the SCA, what would become of that matter that is stayed? Will it still be alive? And if so, what would be the basis, if any, for the parties to continue that matter?
Yes, Justice Matobo, I can say that the applicants have raised exceptions against that action, but the hearing of the exceptions have been stayed by agreement between the parties until we have a final decision on whether the tender awarded is constitutional or not. So that will then, the exception deals with the fact that the applicants have instituted a state self-review against.
Well, sorry to interrupt you, does the outcome of this case have any bearing at all on that future litigation?
Yes, no, for sure. If this...
And if the outcome is in your favor, what would happen to the High Court's case? But
Well-
if the outcome is against you, what would happen to that litigation?
If the outcome is in our favor, in the applicant's favor, of course, the applicants can raise the defense and that was also profit or foreseen in the exception, that the contract is unlawful, constitutionally invalid, and therefore the respondent or Zeal cannot rely on any contractual remedies. So that will be the effect. If the order,
Would that be the end of the litigation?
yes. Oh, I would submit so, yes. If the order goes against us here, the applicants will have no defense,
Yeah, that's,
to raise none. We cannot even raise the Wilkin versus Collar rule. We can't. Because the contract has now been reinstated. And that is the argument by the respondent. The respondent is of the view that that is what they wanted to attain, to reinstate the contract. First, to have it declared lawful by the Supreme Court of Appeal, so to set aside the High Court's order of constitutional invalidity. Alternatively, to reinstate the contract so that they can proceed with their claims of specific performance, payment of 3 invoices, alternatively, or not alternatively, in addition to the action already instituted, the lost profit action. Yes. The applicants will have no defenses, none.
okay, thank you.
Ms. Ellis, as you said, there's no one-size-fits-all when it comes to a Section 1721B remedy. And I think when we read all pay and no profit and no loss, we must remember what you said, because I think you are correct. In all pay, bear in mind that to some extent the just and equitable remedy was forward-looking, because SASSA wasn't in a position at that stage to continue paying the grants, and therefore CPS was going to be required to do so despite the invalidity of the contract, first for the balance of the 5 years and then even another 18 months after that. By contrast, Gajima, Buffalo and Pamela were backward-looking. Services had already been rendered and then the contract was declared invalid. Now, if we take Gajima and Buffalo, which are decisions of this court, by preserving accrued rights, the contractor, the innocent contractor, was entitled to the benefit of its contractual rate. If it performed the contract efficiently, nobody tenders for a contract without factoring in some profit. So if in Gajima the contractor was allowed the contractual rate, unless it had performed the contract inefficiently, the contractual rate would have given it, covered its costs and allowed it a profit margin. And the same is true in Buffalo City, is that not so?
Justice Rogers, I have difficult...
Those orders did not say you're entitled to compensation for your out-of-pocket expenses. The accrued contractual rights were preserved, which gave the contractor the right to claim the contractual rate.
It preserved the contract in order to allow them to claim their accrued rights. However, Justice Rogers, I do not interpret those orders to mean that it includes all the profit margins.
If the contractual rights were preserved in respect of the period for which those contractors performed, it must be the right to the contractual rate. And that rate, in the nature of things, would have included a profit margin. The court was seeing itself as granting not the contractual rate, but something outside the contract, just as just and equitable relief. It wouldn't have preserved the accrued contractual rights. It would have instead made an order under 1721B for the recovery of out-of-pocket expenses. That wasn't what this court did in Kajima and Buffalo.
But wasn't the matter also referred back to the High Court in order to determine the accrued rights?
Yes, but I mean, what the accrued rights were determined by the contract, nothing else.
I don't know. I don't know what was the effect of that.
Falls into the same category. And In fact, although it doesn't have precedent value, this court refused leave to appeal in Pomelo on the basis that an application for leave to appeal lacked prospects of success. Now, that doesn't have precedent value. There wasn't a judgment of this court. But I think that outcome would have been based on the footing that it was a sort of case where a Gajima and Buffalo City-style order was more appropriate than simply allowing recovery of out-of-pocket expenses or allowing nothing.
Yes, because in Pomelo, that might be the case, because in Pomelo, the contract has already run its term.
Yes. As I say, all pay might have been different because it, to some extent, was forward-looking, and it was then known that services were going to be rendered in the future at a time under a contract which was known by then to be invalid. And that might have been a no profit, no loss principle. I accept that in the Central Energy Fund, where I was in the High Court, and my approach was the same as what the SCA subsequently did, also applied no profit, no loss. So it seems to me that one can't say absolutely that neither type of order is permissible. It can either be preserving accrued contractual rights, or it can be no profit, no loss, which is simply an extra contractual order, simply entitling the contractor to recover its out-of-pocket expenses under the Constitution, not under the contract. And since the court assessing the remedy will take into account all the circumstances and then exercise a true discretion, if that is defensible, if it lies, as it were, in the continuum of what a court properly directing itself could do, then that outcome might stand. So one can't say that every case is only out-of-pocket expenses or every case is only accrued rights.
No,
It might be one or the other. Now, it seems to me in this case, in respect of the period June to 12 August 2015, Zeal was performing services in the belief that it was doing so under a valid contract, and it did what it had to do. And for present purposes, we accept it was an innocent contractor. If the SCA had said, Zeal may have its accrued contractual rights in respect of the period June to 12 August 2015, in other words, to recover for that period at the contractual rate. In other words, on the Gajima-style basis. It seems to me it would have been very difficult for a court to say that that wasn't the exercise wasn't the proper exercise of a discretion, even though the contractual right would have allowed Zeal some profit in respect of that period. By contrast, it seems to me to be fundamentally different after the 12th of August, because at that stage, Zeal didn't perform the services. It actually told its network of doctors not to, as it were, provide services at Zeal's expense. Veterans who came to any of the network doctors after the 12th of August had to pay cash. So no services were in fact rendered, and one might say in respect of that, there should be no profit, no loss. So that if Zeal did in fact incur some costs in respect of this contract after the 12th of August, we shouldn't deprive it from recovering those costs, if there were any costs in maintaining its network or whatever, but that it shouldn't be entitled to accrued contractual rights. Because when I read the SCA judgment, and to some extent my colleague Justice Nichols has already raised this, if you read the SCA judgment, you would almost get the impression that for 3 years Zeal had simply carried on rendering the services. The SCA judgment doesn't seem to give recognition to the fact that it in fact did so, not because it was at fault, but it in fact did not do so for more than 3 months. So if this court were inclined to interfere, particularly in respect of the period after 12th August, in other words, for the 33 months rather than the first 3 months, is there any reason why we should not at least allow Zeal its contractual rate up to the 12th of August 2015, a la Gajima and Buffalo City?
Justice Rogers, the applicants, the case for the applicants is that that will infringe or that will not be a just and equitable remedy in the circumstances as was the circumstances in Gijima and in Buffalo. In Gijima and Buffalo, the tenderer was allowed to continue with the services.
That is true of Zeal up to the
No,
order.
yes, but part and parcel of the reasons why the court declared the contract unconstitutional and invalid is because there was no budget, there was no monies for those invoices or the contractual. So to say to an innocent, to say to it, or to say to an organ of state, is you must now run the risk that if you tender for services and the award of the tender is irregularly awarded in terms of the procurement process, you run the risk of having to compensate an innocent tenderer for profits, including any losses.
Well, in the situation you sketch, the fault doesn't lie with the tenderer, with the contractor. It wasn't for the contractor to inquire whether you had the budget. The department knew when it awarded the tender what its budget was, and it allowed Zeal innocently and without knowledge of the defect to perform its services for 3 months. But either way, may I just say this, or put this to you? If we find that the SCA did not exercise, the High Court manifestly didn't exercise a discretion, it didn't consider a just and equitable remedy. The SCA applied its mind to a just and equitable remedy, but we might find that it didn't do so in a judicial fashion because it ignored fundamental problems. That would then mean we are at large to provide a just and equitable remedy. And in respect of the first 3 months, we may treat the first 3 months quite differently from the other 33 months. And in respect of the first 33 months, we will be at large then to decide whether the compensation should be at the contractual rate on an accrued, preservation of accrued rights basis, as per Kajima and Buffalo City, or whether we should limit Zeal to out-of-pocket expenses.
If I understand that statement correct, Justice Rogers, it means that if this court decides to compensate Zeal on a contractual basis, that presuppose that the contract must then be reinstated, or the invalidity of the contract.
The accrued rights will be preserved up until the 12th of August, when the services were ended. There's nothing anomalous about that. I mean, if Zeal had accepted a repudiation on the 12th of August 2015 and cancelled, there would have been accrued contractual rights up to the date of the cancellation. After that, there would have been a claim for damages. So there's nothing anomalous about preserving the contract, the accrued contractual rights for the period where the services were actually rendered.
Yeah, but that will entitle Zeal to also claim profits.
Yes.
So the principle...
It will entitle it, but what I was putting to you is not that that would actually be this court's decision. I was
please
putting
not.
to you that this court would be, if the SCA didn't exercise its discretion judicially, we would be at large to exercise our remedial discretion. And the choice we might face in respect of the first 3 months is whether we should adopt a Gajima-style approach of accrued rights up until the 12th of August 2015, in which case we would allow Zeal its contractual rate, including its profit margin, or we would take an out-of-pocket expenses approach. Either of those would be the two choices that would confront us, but we would be at large to decide what to do. We are not then bound by anything the court below has done.
I agree.
Yes, thank you.
And you would contend that we should fall on the latter part, the out-of-pocket expenses,
Indeed.
notwithstanding the engagement that you had with my brother Rogers, on the contractual rate, any tenderer that tenders for a contract, invariably there are profit margins in that contract. It cannot be simply a contract without any profit margin. Otherwise, what is the purpose of that?
Yes, but Justice Matopo, that is exactly what the no profit, no loss principle stand for, is that if you tender, you run the risk, if the process is declared unconstitutionally invalid, you run the risk of having to forfeit it, your profits, your prospective or your retrospective profits.
But if you say you run the risk, doesn't one have to factor into the equation the party who runs the risk, his or her contribution or its contribution? In this case, we have Zeal, which was an innocent party, one, and as my brother put to you, the issue of the budget has got absolutely nothing to do with it. And in fact, Zeal didn't know that the state organs did not have a budget. And what happened at the background? Why should it be laid at the door of Zeal and deny its contractual rights, including those profit margin, up to the extent of the period 1st June to the 12th of August?
Justice Matopo, in that instance, this court will give credence then to the Pumelu judgment. If that is this court's, because that is what the Pumelu, the effect of the order in the Pumelu judgment is just that.
No.
That if you are an innocent tenderer.
No, but shouldn't you try and look at the facts in Buffalo City, the facts in Kijima, and the facts in Olpay, and see whether those facts fit in squarely with the facts in this case?
Not at all.
Not at all.
The facts differ totally
So if
in this matter from the facts in Kijima, Buffalo, and in Olpay.
now,
Totally.
if we are to find that there is a difference in the facts, right, and we are to say the SCA did not exercise its discretion, its true discretion properly, then it means we would be at large to exercise or to apply a just and equitable reliever order in the circumstances. And if we are to take into account to say the three cases that I have referred you to are clearly distinguishable on the facts, and the facts in this case are this, and on these facts, it would be wrong not to grant Zeal its accrued rights, which includes up to the 12th of August, which includes its profit margin, if any. Just imagine, and you take it backwards. When the tender was open or invited, it had to do some mathematics to say, this is a viable tender, and it put up all its network resources in advancement or in completion or fulfillment of that tender. And now, lo and behold, it is discovered that the tender was bereft or marked by irregularities which it has no knowledge of, and now it is told, walk away from it. Whatever came out of your pocket is what you're supposed to get. Would that be a just and equitable way of treating an innocent tenderer who had no fault at all?
Indeed, because it is
Indeed,
akin to the
it's
no
correct.
profit, no loss principle. Yes.
But why?
Because that is what must happen, especially in private law.
But are we not rigidly and inflexibly applying that? You have said to us that the SCA paid scant regard to the just and equitable relief remedy, and you said on that basis we should interfere. And you've listed the facts, the controlling law, the constitutional principles. And I'm bringing those factors differently to you to say, armed or faced with those, what do you do? Do you walk away from it?
Justice Matopa, if I may pose your statement in, I want to turn it around.
And I'm not going to answer it, you know that.
No, I'm not asking for an answer. I will put it hypothetically. Hypothetically, you must remember that this matter, so Zeal started this matter by launching an urgent application asking for the payment of the first 2 invoices. If the applicants or the Department of Military Veterans have indeed paid Zeal Health the first 3 invoices and then only instituted the state self-review, on the case law and on our understanding of what is a just and equitable remedy and what the purpose of the SIU and the special tribunal is and the work of the SIU, we would submit, or I would submit, that in those circumstances, nothing would have prevented the Department of Military Veterans from reclaiming the profit in the event that they were successful in having the tender declared unconstitutional and invalid, unlawful. Because the just and equitable remedy must equally apply to an organ of state as well. Everyone is equal before the law. So in that instance, I would submit that this court would have had great difficulty in denying such a claim from the Department of Military Veterans to reclaim the profits made by Zeal Health under an unlawful, unconstitutional contract. And that is my submission on.
Thank you.
Advocate Ellis, maybe you can help me. What was the value of the tender that Zeal applied for and was granted?
It was 198 million rand.
So it was granted.
That was granted.
Was that the advertised contract, 198 million? Because we don't have those documents.
Deputy Chief Justice, as I can recall, I talk under correction, I don't know if the tender documents or the advertisement of the tender specified the contract price. No, it did not. No.
So it
no.
was an open-ended tender?
It was an open-ended tender, yes.
Thank you. Thank you very much, Ms. Ellis. There are no further questions for you. No. Thank you. You may go ahead when you're ready, Mr. Curry.
Thank you, Deputy Chief Justice. Deputy Chief Justice, members of the court, I will deal with two aspects. First of all, whether the department's case meets the standard required for an appeal against the exercise of a true discretion. We submit that it doesn't. It simply just doesn't get there. Secondly, I'll deal with the question of just an equitable remedy should this court nevertheless hold that it will grant leave to appeal and it will consider itself at large to consider a just and equitable remedy in this particular case. The background story to this case is a quite simple story, and it's all in the papers. In 2015, Zeal Health, which is a very small company operating in the managed healthcare sector, obtained a contract from the department. And it's undisputed that it performed services under the contract. It provided healthcare services to military veterans until, in effect, it was forced to stop doing so because it was not paid and because the department repudiated the contract. And it has never been paid, not 1 cent in all of these 10 years, not for the work it actually did, nor for damages, nor even for any of its out-of-pocket expenses, which is now what the department urges in this court. The department has said in its founding affidavit in the application for leave to appeal in this court that it has always tended to pay Zeal's out-of-pocket expenses. That's simply not correct, and it's dealt with in the opposing affidavit. Faced with non-payment, Zeal applied on 28 September 2015 to the High Court on an urgent basis to seek payment of what was at that stage its 2 invoices that it had rendered for services in July and August of 2015. Its basis for urgency, as was set out in the original founding affidavit, was that it was providing an essential healthcare service to military veterans. And the particular segment of the veteran population, the military veteran population that is served by Zeal Health and by this particular contract, are the veterans of the non-statutory forces. And it's set out in the founding affidavit as to why this is a particularly vulnerable population. If it was not paid, Zeal Health could not afford to keep the operation that it commenced running, and it would have to shut its doors, and veterans would suffer. That was the basis of urgency. And that's set out in a nutshell in paragraph 68.3 of the founding affidavit. That's at page 29 in volume 1. Zeal Health says, the beneficiaries of the healthcare and wellness program are veterans who are unemployed, living on state pensions, who are employed but have no medical aid cover or inadequate cover. Many, if not the majority, are unable to afford to pay cash for healthcare and wellness services and unable to afford the cost of traveling to a SAMS, SAMHS facility. Certain services provided by the program are simply unavailable from the medical health services of the SADF, such as home nursing or psychological counseling services. Zeal was being stonewalled. It was not being paid, and its attempts to find out why were ignored by the department. And it explains in its founding affidavit in the urgent what result this had and why it was unsustainable for it to keep providing essential services with mounting costs in the face of non-payment. It's referred to in the heads, and I'll just give the court the reference. It's paragraph 35 at page 21 of the founding affidavit. It's detailed in the founding affidavit how Dr. Vaisi then reached out to various officials in the department to try and resolve the crisis, but it was stonewalled, and it continued to be stonewalled until it launched the urgent application, and the department filed its answering affidavit in October of 2015. In that affidavit, the department said it did not have to pay Zeal because the contract was, quote, unconstitutional, invalid, and void ab initio. That was the formula it used in the notice of motion and repeatedly throughout the litigation. And that has been the department's stance ever since, is that if it is, in its own view, unconstitutional, invalid, and void ab initio, it excuses the department from performance and from payment under the contract. It took the view that this excused it. It could carry on as though there was no contract. It didn't apply for an order suspending the contract. It did not purport to cancel the contract. It just ignored it and said that it didn't have to pay because the contract was invalid. In my learned friend's heads of argument at paragraph 17, it's contended there that Zeal was informed on 11 August that the department intended to seek judicial review, and consequently the DMV did not affect payment of the invoices submitted by ZHI. That's not correct, and I would urge the court to consider the footnote reference, which is it leads to FA 26, which is at page 45 of volume 1. And if the court considers the letter that's relied on as evidence for this proposition, it's quite clear that that letter does not inform Zeal Health of the department's intention. It's plainly what the attorneys call a holding letter, nothing more. It says we've referred this to the state attorney. It's a response to Zeal's earlier letter of 11 August. You can see that from the heading. The heading that says intention to seek judicial review is Zeal's heading, not the department's. The department simply copies Zeal's heading. It itself gave a completely non-committal response. Justices, it's simply incorrect to submit that Zeal was told about the department's intention to seek judicial review and that it somehow then carried on at its own risk. The fact is that it's only on 30 October 2015 that the department informed the military veterans, and this is in a letter that is annexed at LZM 40, which is at volume 2, page 223. The department on 30 October informed military veterans that Zeal Health is no longer rendering services for this department, and they must go instead to South African Medical Health Services. And that exemplifies the department's attitude. It simply repudiated its obligations. It had formed the view that the contract was invalid, so Zeal would not be paid. It denied the existence of the contract. It effectively locked Zeal Health out of the contract. Zeal was not paid, and the urgent application to be paid was struck from the roll. And Zeal then embarked or continued with the litigation that is now 10 years later reached this court. Having effectively been locked out of performing the contract, it persisted in seeking payment of its 3 invoices, June, July, and August 2015, plus interest. And crucially, it continued to tender its services. My learned friend said it didn't, but that's absolutely incorrect. It did, and that's quite clear from, I'll give a single example, replying affidavit in the urgent, which is at page 139, paragraph 37. But I'll make further submissions which make it absolutely clear that Zeal's entire stance was that it came to court to say, we demand specific performance. We want to be put back into the contract, and we want to be paid for what we've done already, and to be reinstated. Effectively, it didn't accept the repudiation and tended to perform and sued for performance. That was its entire stance in the litigation. What happened, though, is that the matter got nowhere near court for the duration of 2017 and 2018. And you'll recall that it's a 3-year contract. Its expiry date is May 2018 in any event. So Zeal cancelled the contract in April 2018 due to the department's ongoing repudiation. And the department has resisted paying Zeal Health for a decade on the basis that the procurement process and the contract was unconstitutional, invalid, and void ab initio. And until these proceedings, its stance has been that Zeal Health is not entitled to be paid anything under the contract because it is invalid, void, and ab initio. The department refused to countenance that justice and equity might require that Zeal Health is paid something despite the declaration of invalidity. The High Court held that there was no evidence that Zeal Health was complicit in any of the irregularities in the department's procurement process, and the department did not challenge that finding. It did not challenge that finding in any way on appeal, and the finding stands. Yet, even in the appeal in the SCA, it persisted in contending that Zeal Health's only remedy was to bring an enrichment claim for its services actually rendered, which does not include any profit margins. Zeal Health in the SCA asked, in the alternative, its first stance was to defend the regularity of the contract and to say that none of the review grounds should stick, none of the review grounds should be upheld. But in the alternative, if the court should find that any of the review grounds have merit, that it should be granted as a just and equitable remedy a Buffalo City order, preserving its accrued contractual rights despite the declaration of invalidity. And in response to that, the department said, it is respectfully submitted that the circumstances do not warrant this court exercising its remedial power by preserving the contract. It did not elaborate on what it thought those circumstances were. And against that background, it's quite startling from the perspective of those involved in the litigation to read in the founding affidavit in the application for leave to appeal at paragraph 65. Justices, I'm referring to volume 5, page 452, paragraph 65 of the founding affidavit in this court. The department says, after having raised ZHI's so-called alternative relief mero moto, the SCA was urged to grant a just and equitable remedy in terms of section 172. The first point to make in respect of that is that it's deeply troubling that the department can make that submission in an attempt to persuade that something irregular occurred in the SCA. The SCA did not raise just and equitable relief mero moto. It is entirely incorrect because Zeal Health expressly asked for this relief. And it asked for it as long ago as 2016 in its answering affidavit to the original counter application. May I take you there because it's an important passage and there are several paragraphs referred to which are of considerable importance for the current debate. I am at volume 2. Apologies, I'm at volume 4 and I'm at page 252 of the record. And this is the the answering affidavit in the counter application by Zeal Health. And starting at 118, Zeal Health persists in seeking the relief set out in paragraphs 2, 3, and 4 of the original notice of motion, subject to the following qualifications. As to prayer 3, amounts due and payable at the date of judgment, Zeal Health invoiced the department in respect of June, July, and August 2015. The invoices are attached. It seeks payment consequently on terms of those invoices of 15.7 million rand. It also seeks interest on the amount a tempore mori. It says at 118.2, the department has not established any basis for the review of the impugned decisions. Zeal Health reiterates the tender it made in the founding affidavit to perform all its obligations in terms of the contract. The contract between Zeal Health and the department is thus valid and binding, and Zeal Health respectfully seeks a declaration to this effect. It declined to accept the repudiation and it asked for an order of specific performance. It continues, as a matter of justice and equity, Zeal Health should be put in the position it would have occupied had the department not reneged on its contractual obligations, i.e. as having been contracted to provide health and wellness services for a 3-year period. And then it proceeds to elaborate on the problem that it faces and why it's necessary to obtain that. After 3, and this is the bottom of the page, just this is at 252. After 3 months, owing to the department's obstruction, Zeal Health was forced to scale down the level of services provided and then to suspend services altogether. It could thus not provide the full set of services required by the contract. And then at 118.4, even if it is reinstated to its contractual position, Zeal Health will not recover out-of-pocket expenses that it incurred due to the limited provision of services that it provided during September and October 2015. Recall that the repudiation occurred at the end of October 2015. Until that point, Zeal, although it had scaled back its services, was compelled to continue to provide services in emergency cases to veterans and require cash for that. But nevertheless, it was required to absorb the cost of maintaining its network and its system in order to comply with this legal requirement. And if you have a look at 118.5, it says, military veterans thus continue to request and were provided by Zeal during the period of September and October 2015. It's incorrect to state that Zeal walked off the job, as it were, in middle August 2015. And at 118.6, I'm now at page 254. In these circumstances, Zeal Health will seek an order that it must be paid for all amounts due and payable for it, for out-of-pocket expenses, etc., in respect of that period. So it went to, what then occurred, of course, was that it didn't reach court and it cancelled, and it then sued for lost profits, essentially, in relation to the executory portion of the contract. But in respect of its accrued rights, the invoices, those 3 months of invoices, it continued to press in the SCA for an order that it be paid that money, and it be allowed to, if the contract was preserved, its accrued rights would include its ability to continue to proceed with its contractual claim in the High Court, which had been stayed. I don't take that one. By the time of the SCA appeal, the contract had been cancelled and it would in any event have expired in 2018. And in the meantime, the law on just and equitable remedies in the procurement context, from this court and from the SCA, had developed considerably. I point out, Justices, that Gajima was in 2018, Buffalo City was in 2019, Shabangu, which clarifies the scope of the all-pay, no-profit principle, was in 2020, Pomelo was in 2023. So, in 2024, Zeal Health asked in the appeal, in the alternative, and if the review was upheld, for a Gajima-type order preserving its contractual rights despite the declaration of invalidity. It asked also that the contract was not set aside, but preserved, so that Zeal could continue to press for its accrued rights. It's not a case that it was asking to be reinstated to the contract. The contract has been cancelled, and in any event would have expired. And what that meant practically in the SCA is that Zeal was asking, if the order was granted, it should be paid its 3 invoices plus interest, unquestionably accrued rights. And second, it would mean that its damages claim for lost profits, which had been parked in the High Court in the meantime, could be proceeded with. The department then says, I'm referring again to paragraph 65 of its founding affidavit, is that the SCA was urged to make a just and equitable order in accordance with the principle of no loss, no profit enunciated by this court. Well, we have a different recollection of that, but it's neither here nor there, because the submission rests, I would submit, on a fundamental misunderstanding of the scope of that principle in all pay. Shabangu clarified that the order was given in the context of a suspension order, the continuation of an unlawful contract, because of the circumstances of that particular case required is its CPS to continue to provide services. And for that period, the court said it should not be entitled to be granted a profit. What all pay doesn't establish, I would submit, is some sort of general rule that's applicable wherever an organ of state obtains the review and setting aside of its own contracts. And to listen to my learned friend's argument, it's as though you just have to say those words, no profit, no loss, and the court will not grant a remedy preserving the contract. The SCA rightly rejected the notion that justice and equity in the circumstances required that Zeal Health derives no profit. And they did so judicially after consideration of the facts and circumstances. And that should be the end of it. Nevertheless, in this application, the department still persists in trying to avoid paying Zeal Health under the contract. And it does so on the basis that there's the supposed generally applicable principle, almost arising to the level of a rule. And it's notable that the department doesn't have any kind of systematic or coherent case as to why, in this particular case, justice and equity require that Zeal should only get out-of-pocket expenses. It's because of its conviction that there's a rule applicable. No profit, no loss. No service provider is ever entitled to profit from a contract that has been declared invalid. The department then says, I'm talking about paragraph 65, it made submissions based on Bravo Span SCA. Again, we have a difference of recollection about that. But it's hard to see what the SCA should have made of such submissions because it's incoherent. Bravo Span is an unjust enrichment case. It's not a contract case. It cannot be understood why the SCA is being criticized for not following Bravo Span and granting Zeal Health a right to compensation in unjustified enrichment when it brought a contract case. It brought squarely a contract case asking for its contractual rights to be preserved. The department has to establish a basis for the appeal of the exercise of a true discretion. And the whole basis of that application simply fails to meet that requirement. One, it says, mero motu, the SCA granted a just and equitable remedy to Zeal Health. That's fundamentally baseless and inaccurate. It wasn't mero motu. Secondly, it said that the SCA rejected out of hand the proposal of a Bravo Span order. That proposal was never made, as I submit. But in any event, the SCA makes no mention of it, and it could hardly be said to have misdirected itself by rejecting it. And then for the general no profit, no loss principle, it's been established in Pamela. The SCA expressly rejected the notion that there is a general no profit, no loss principle. And it overruled Venus Reyes on this point. In Venus Reyes, and that really should dispose of the application. It is entirely meritless as an application for leave to appeal against the remedial order. In other words, the appeal against the exercise of the true discretion that was exercised. What the department seeks in this appeal is a declaration that Zeal Health is entitled to compensation for its out-of-pocket expenses for the services rendered during the period 1 June to 12 August. 12 August is the period where it says Zeal Health walked off the job, as it were. Now, there's a number of problems with that remedy. The first is that there's no prayer to have the contract set aside. The SCA preserved the contract. There's no setting aside order. The department doesn't ask for one on appeal, and I can see why. It's because it thinks a declaration of invalidity is exactly the same as a setting aside order. The remedy of the declarator that's asked for doesn't disturb the preservation of the contract. The relief is incoherent, and it's unsustainable for that reason alone. The second problem is that this is an entirely new case that was advanced in this court for the first time. It's not pleaded. There's no trace of it in the record. If the proposition was put to Zeal Health during the proceedings, prior to the High Court judgment, it would undoubtedly have answered it. It would first of all have dealt with this notion of 12 August 2015 as being some kind of cutoff date. And it would undoubtedly have put up evidence to show that what this would practically mean for it and why it would not have been just and equitable. But in the circumstances, that never occurred. And it never was given that opportunity because it's raised in this court for the first time. To consider it now an appeal would be unfair to Zeal Health. What does justice and equity require? I would submit, and have submitted in the heads of argument, that the remarks made by this court in Bravo Span, in the CC judgment in Bravo Span, have an application here. Paragraph 60, this court said, it made reference to a broader phenomenon of organs of state seeking to rely on their own unlawful contract conduct to avoid compensating innocent contractors for services that those contractors have provided to them. The court must make clear that conduct of this sort should not be tolerated. And at paragraph 48, both the Supreme Court of Appeal and the High Court were agreed that after close to a decade of waiting, Bravo Span should receive compensation for the services that it provided to the municipality. Organs of state must pay for services that are provided to them by an innocent contractor, and I would submit it must be paid, they should be paid on the contractual basis. That was the basis on which the contract was performed, the basis on which the service provider agreed to perform the services. And it should be granted its contractual price for those services, including profit, where there is profit. There will inevitably be profit. The High Court found that Zeal was an innocent contractor. There's no challenge to this finding, and it must follow that Zeal should be paid, and paid under the contract, I would submit. Not on some other basis of unjustified enrichment or restitution. This is a textbook case of what the court observed in Bravo Span to be a phenomenon of organs of state seeking to rely on their own unlawful conduct to avoid compensating innocent contractors for services that those contractors have provided to them. The department, under one set of management, concluded the contract, it let Zeal Health get started and spend fortunes of money, and then, with the departure of the former Director General, it then set about repudiating the contract. The evidence in the record is that it did so because the Minister of Defence said that she instructed this. Zeal Health should not be paid. She thought the contract was too expensive. That's not the reason given in the department's affidavits, and we say that its defence of Zeal's application has been a dishonest defence for that reason. It's dealt with and elaborated on in the heads of argument. As to the core point, as it were, which is the point on which it did succeed in the SCA, the department's core point, the financial provision. The correct figures have been litigated on and now dealt with in paragraphs 15 to 19 of the SCA judgment, particularly paragraphs 17 and 19. And the essence of the problem was, as the SCA saw it, that in terms of Section 38, the DG should not commit to a liability that had not been budgeted for at the time of the commitment. The SCA establishes that principle, but that principle, I would submit, has been cynically abused by the department here. The health services that it procured from Zeal Health were essential services. The department was not buying golf carts or some kind of luxury. It has to service the health needs of veterans. And so, once it reneged on the Zeal contract, it had to scramble to find an alternative. It turned to its MOU with SAMS, but it ended up paying more than it would have paid Zeal Health. And it was also evidently completely unconstrained by the supposed budget cap for the health and wellness sub-program. It was never criticized by the Auditor General for overspending. And my learned friend said this is not on the papers, but it is. It's in volume 3, page 268, paragraph 18, and it's dealt with chapter and verse in my heads of argument. It is in the papers. The department revealed that it overspent some 67 million on the sub-program, and that was a 28 million rand expenditure in excess of what had been originally budgeted for. There was no consequence to that, it seems. The department can find the money if it needs to. It's not like the department didn't have enough money in its overall budget. It just hadn't allocated enough to the sub-program. That is something that a service provider, an innocent service provider, can have absolutely no knowledge of. It's a complete mystery as to how the department budgets, and if it's going to wield this as a weapon to be able to then get out of its contractual obligations, I would submit that fundamentally the constraint must be that the department or the organ of state must be held to its contractual obligations. If it does not, the consequences for innocent service providers to do business with the state, will it simply act as an enormous deterrent? Who would do business with the state, I ask rhetorically, If it was the position that the state can say, oh, so sorry for you, we failed to budget for this, something you didn't know about, and as a consequence, we can't pay you, but we will give you your out-of-pocket expenses. The SCA granted exactly that order. It granted an order saying that despite the declaration of invalidity, Zeal maintained or retained its contractual accrued rights, and it's entitled to pursue that. It didn't grant the payment order of the invoices, but as I read the import of the judgment, it envisages that that will be claimed as part of the High Court proceedings. Thank you, Justice Mlambo.
Thank you, Mr. Kari.
Questions?
Kari, let me just clarify one thing. Is it Zeal's case that it contends for the preservation of their accrued rights from throughout, or there is a cutoff point?
The cutoff point is the fact of the cancellation.
And when is that cancellation?
The cancellation was in 2018, May 2018. But
April.
the way that, yes,
April, when Zeal cancelled.
yes,
So whatever determination has to be made would be from the date of the inception of the contract
yes,
until when Zeal said enough is enough in April 2018.
yes. Justice Matopo, Zeal's High Court claim is a claim for lost profits for the period of the contract. Its claim, its other accrued rights claim it relates to the invoices, and it separated those on the basis that the invoices were never disputed. It's not like the department said, well, you didn't totally provide the services, or the services were inadequate. Its whole stance was, we don't have to pay you anything. Forget your invoices, we're not going to pay you. So the invoices we submitted clear and undisputed, and if Zeal is entitled to its accrued rights, it's entitled to those 3 invoices, and that's a separate matter. And in the High Court is, at the moment, that claim is confined to a lost profits claim, but it is a lost profits claim for the duration, for the lost opportunity of the contract as a whole.
Let me understand it correctly.
Yes.
The invoices is for June, July, and August,
2015, yes.
and they have not been paid, and no payment has been tendered throughout this litigation.
No.
The department says you terminated the contract on the 12th of August 2018 when Zeal indicated that it's no longer required to render the services. You say the actual termination was sometime in October. Did I understand you correctly?
Correct, yes.
It's correct, it's October.
Yes. So we disagree fundamentally with the notion that we terminated on the 12th of August. We simply did not. We continue to tender to provide services. It's a case of the exceptio. They're not paying us. We're unable, in fact, to access the contract because I read the court the letter of 30 October. It says, don't go to Zeal Health anymore. They're no longer
Sorry,
providing this service.
I'm just,
Yes,
I can't
sorry.
hear you properly there. You said 30th of October, that's when the letter was
The repudiation.
from the department
Yes.
itself.
Yes.
So if we are not with the department on the 12th of August, you would say the date on which they unequivocally indicated an intention not to be bound by the agreement or the contract was the 30th of October by virtue of that letter that was sent out.
That was the repudiation. Zeal did not accept it, and it sued precisely for specific performance.
Accept you did not accept
Yes.
the repudiation, but on any outward manifestation from the
Yes.
department,
That is what we submit, yes.
it was the 30th of October.
Yes, the urgent application, which I think the answering affidavit was filed a few days before, it's on the 20-something of September, also gave an indication. But as far as the department's manifestation to, its official manifestation to the veterans, it said veterans no longer go to Zeal Health. That for us was the repudiating moment.
So, from the month of June until October 2015, depending on what the department would want to say, if one were to say you would be entitled to your accrued rights in terms of your contract, including the profits, and if those profits were to include up until the 30th of October on one scenario, would that cover that period of 1st June until the formal
That would cover
repudiation?
that period of 1st June to 30 October, yes, Justice Matopo.
But would there be any facts or evidence that would demonstrate that from the 12th of August, as contended by the department, there is something that Zeal did subsequently to that to demonstrate that indeed it never walked away, it continued?
I've read to you from the answering affidavit in which Zeal Health explains that, first of all, up to the suspension of everything except emergency cases in August, it provided a full suite of services. Those services, it's a capitation managed healthcare contract. It means Zeal Health must create a network. It must have everybody ready to receive whoever comes, whichever veterans come. It did that, and it maintained that service at all the required levels until, I'll accept 12 August as being the date on which it had to scale back. But it did not stop. It did not stop providing services. It had to provide emergency services. And crucially, this didn't stop its expenses.
And as it was providing those services,
Yes.
did it render any invoices?
No, its last invoice was August of 2015.
But then why didn't it render any invoices?
Well, because, I'm not sure this appears from the papers, I think the logic would be that it was unable from at least, once it had rendered its August, let me say this, for September and October, it wasn't providing the full suite of services.
It wasn't providing services.
Well, not the full suite of services, no. It couldn't ask for the full 365 for every veteran for that particular period as an invoice. In other words, it just simply invoiced for it as though nothing had happened. And it did not do so.
Let me tell you why I'm asking this.
Yes.
I'm asking this on the basis that if indeed Zeal did render any services subsequent to the period alluded to by,
Yes.
by the department, it should not be out of pocket
No,
its own expenses.
no.
So that's why I would want from the papers, if there's any evidence that would demonstrate that indeed during that period it did provide any form of services which the military veterans benefited.
The one difficulty with the papers before this court is that the supporting papers, as it were, what you call the annexures have been omitted. But I've read to the court the allegations made by Zeal.
It's that
I
Zeal's
think-
pleaded case.
I stand under correction, but I believe that to be where it set out its case, yes.
Well, I'll look it up, but
Yes. May I just explain, Justice Matopo, the logic of Zeal's litigation in this matter? First of all, in relation to the 3 invoices, it's always said that those are a separate matter. They are uncontested. The invoices are the invoices. The department must pay the invoices plus interest. In relation to what then happened afterwards, in relation to the whole let's call it the period of September to October, when Zeal still had to maintain its ability to provide at least emergency services, and obviously rendered costs for that, it has put those into its loss of profits claim. In other words, that's part of the pending High Court proceedings. So if Zeal was to succeed in that High Court claim, first of all, if it was able to get its 3 invoices paid, one could put that one aside. If it was able to then proceed in the High Court for its claim, it would be put to the position it would have been in had the contract had been properly performed by the department, and those additional expenses, currently not covered by an invoice claim, would be covered. That is the logic of its litigation strategy.
But then now, for the purpose of our just and equitable inquiry,
Yes.
if we are not forward-looking to what the High Court would say or not say, and if we are to say Zeal should be entitled to its, for its services that it has rendered for the period June until October,
Yes.
are we able to ascertain what happened post the 12th of August going to October? It's, in other words, would there be any evidence, or it's part of the loss of profits?
In facts and figures, no. I don't think one could do it on these papers, no.
Can't.
No, but I'm speaking only of the part of the contract not covered by the 3 invoices. In other words, the September-October provision period. We submit that Zeal's contractual rights are complete, are a simple matter, or a kind of done and dusted matter as regards its 3 invoices. But it's this subsequent period when it eventually, it basically scaled back entirely because it knew that the department had repudiated. Those, I don't think there's sufficient specificity in the papers to give it a rands and cents amount. Apologies, if I may just, my attorney's just referring me to. Yes, just on this particular period and the 12 August period, my attention's just been drawn to what is said in paragraph 27 of my heads of argument, Justices. Services were rendered in full for June and July and up to 12 August, despite non-payment. 12 August, Zeal sent a communication to its provider networks to provide emergency services, which is a legal obligation, and to take cash, and it said it would refund that cash. Zeal Health claimed for the full amount of its August invoice. It alerted the department to the fact that it would be liable for the full amount due, even if only emergency cases were looked after. The department has never opposed Zeal Health's claim on the basis that the full suite of services was not provided after mid-August 2015. That's simply never been its stance, as I've indicated. But to return to your question, the exact quantification of that period, it's not going to be able to be done on these papers before this court.
Yeah, but remember, the exact quantification of that period relates to the period in which Zeal had instructed its service providers to get cash
Yes.
from the veterans.
Yes.
And did Zeal during that period bill the department for the services that was
No,
rendered?
it did not bill.
So then it would mean that that would be, if Zeal is successful, would be part of Zeal's loss of profit, if any, that would have to be adjudicated
Yes.
before the High Court.
Yes, it would be taken care of. I don't think it would be necessary for Zeal to get into the rands and cents of this period because it would be taken care of by its overall loss of profit.
Now, for the purposes of what we are about, the just and equitable
Yes.
relief or remedy, where should we end?
Well, our submission, Justice Matopo, is that the SCA's order is unassailable. The SCA's order is that the accrued contractual rights are preserved.
Well, the SCA
That must-
order,
yes.
sorry to interrupt you. When you read the judgment of the SCA order,
Yes.
it's confusing and confused in terms of the paragraph 24 in the order.
Yes.
There's a serious disjuncture there. And this is one of the factors that would say to us, we are now at large
Yes,
to look at the judgment of the SCA anew.
yes. If this court was at large, to consider itself to be at large, to reconsider that order, what we would ask for is, there is an element of lack of clarity. We've also knocked our heads about this. I'll give you our interpretation of how we understand the order, but what would provide clarity, at least as far as Zeal Health's rights are concerned, is to say what the fate is of those 3 invoices. If the 3 invoices, which we submit, are undisputed and there and represent the obvious proxy and quantification of Zeal's what Zeal has lost in terms of the contract for that 3 months, then it's unassailable. That really should be granted plus interest. It's really not particularly difficult. And we did ask the SCA to do that. For reasons it hasn't given, it drew back from that. And I think the idea was that it should be kicked into the High Court proceedings, which are referenced on the papers. As regards those proceedings, we see the SCA order as preserving those, and Zeal must go and prove its contractual entitlement in those proceedings. We would request that this court retain that part of the order. Clarity in relation to the 3 invoices would be of enormous benefit to everybody concerned, I would submit. But as regards that executory portion, I don't think that this court can do it. And if the court is inclined to preserve that aspect of the remedy, I don't think there's any alternative but to proceed in the High Court to quantify it.
If you get your 3 invoices, that would not put Zeal out of pocket for those 3.
For that period, no.
But Zeal would still say, I'm entitled to the remainder of the contractual price.
May I make submissions on why we say that, Justice Matopa? Because I can see from the discussion with my learned friend that is where the court has a hesitation. As I understand the underlying principle of the Gajima or the Buffalo City type order, it's that an innocent service provider, which is, call it the victim of departmental irregularity for some other reason. So the department proceeds to review its own contract on the basis that it did something wrong, and it has nothing to do with the innocent service provider. As I understand the logic of those cases, it says that the correct and appropriate remedy in most instances in those cases is to say that your accrued contractual rights should be preserved. And your accrued contractual rights must include, because if this was, think away for a moment, the state involvement in this. If this was a purely private sector contract, the counterparty has thoroughly repudiated. It repudiated the contract, in response to which Zeal is entitled to sue for its lost profits. Any service provider would be able to, and it's no answer for that private entity to say, well, isn't that bad because you're getting something for nothing, as it were. You didn't perform the services. Nevertheless, you're able to claim your contract. That is the contractual position. And our submission would be that if it's in the interest of justice and equity to preserve contractual rights, the totality of those contractual rights should be preserved, and that there shouldn't be a distinction between rights in relation to services actually performed versus the executory portion of the contract, which was never allowed to be performed in these circumstances. Zeal was locked out, wanted to perform, but it never was allowed to. If this was a pure contractual matter, it would have a damages claim. The state is involved, and hence there is a different law that applies to it, the law of justice and equity. But our submission would be that the ordinary contractual remedy provides the justice and equity in most instances in this case, and that is what the SCA ordered. It saw nothing unjust or inequitable in the idea that Zeal Health should be able to claim in those future proceedings the full amount of its lost profits.
Thank you, Mr.
Mr. Carrier, over here. Okay.
Yes, sorry.
I'd just like to explore 2 issues with you. The first is you say that the SCA did not set aside the invalid contract, correct?
Yes.
The High Court did though.
Um,
In,
I think that's correct, Justice.
in
I
paragraph,
would have to look.
in paragraph 3 and onward in its order.
Sorry. I have the order here. Apologies, please bear with me. That is my recollection. I just want to make
I
certain.
think paragraph 8, it doesn't give the date, but it says the contract between the applicant and DMV is declared
Contract is-
unconstitutional,
yes.
void. And then it, in paragraph 9, it sets aside
Yes.
the memorandum of understanding and
Yes.
the payment orders, etc. Correct.
I think the intention of the High Court, and there was some difficulty with the High Court in this regard. I think what it intended to do. No, yeah, correct. It isn't. It was not set aside. It appears to be.
Did set it aside.
It doesn't look like it.
Okay. Well, what confuses me,
Yes.
and if you'll just bear with me, is that the SCA agreed with every aspect of the High Court's handling of the matter and its order, except on one aspect,
Yes.
and that's to be found in paragraph 22, that the High Court did not consider just an equitable remedy. In that regard, it erred.
Yes.
It agrees that the High Court correctly reviewed and set aside the decision to enter into the memorandum and the issue of the government order.
Yes.
What would be the effect of the setting aside of the memorandum, the government order, but not the setting aside of the contract?
The
That's-
memorandum.
You're arguing today.
Our submission in the SCA, and this was dealt with in oral argument in some detail. It doesn't appear in the judgment, but it was dealt with. Our submission, and it was in the heads of argument, is that MOU, it was entirely irrelevant. It had nothing to do, it wasn't an MOU that governed the services between the department and Zeal Health.
Well, except that the SCA found that there was no lawful basis for it, not that it was irrelevant.
The SCA dealt only with one aspect of the review grounds, which is the financial aspect, the budget aspect. Implicit in the order, I would submit, is that it found, the rest simply didn't find favor. It said, this is the review ground, and it substituted the order on the basis of that sole review ground. It preserved none, and if you have a look at the order of the High Court, the order of the SCA at 27, it says it sets it aside and replaces it with the following, and nothing is left of the High Court order. None of the High Court order was preserved, including those orders relating to the MOU, etc., the interim services contract. All of that was implicitly held to be irrelevant.
So are you saying that the SCA in its paragraph 1 order left intact? It declared it invalid, but it didn't set it aside?
The contract?
Yes.
Yes, yes. And that's what it was asked to do. It was asked to declare, if it's going to declare it invalid, but not set it aside and preserve the contractual rights. Not setting aside does not have the effect that Zeal Health is entitled to be a service provider under it. It's simply the method by which its accrued rights are preserved despite the declaration of invalidity, as we understand it. And that's what that was what the High Court, the SCA was urged to do, and that's how I interpret the order. It didn't set it aside precisely because it wanted to preserve the accrued rights under it, as per the Gajima order.
So as I understand your case, your client's case now is that it goes to section 172 to seek a just and equitable remedy in respect of the first 3 months
Yes.
of the contract, where it's provided the services.
Yes.
But it relies on the continued existence of the contract.
For purposes of the claim.
Damages.
Yes. The contract has been cancelled and has expired in any event, but the accrued rights have been preserved. That's what we seek, and would ask that this court does not.
Nothing in the SCA judgment that assists us in this thinking, not so, because it doesn't deal with that aspect at all. I mean, if you start reading the SCA judgment, you would think this judgment is about a just and equitable remedy, period, correct?
Sorry, I didn't quite.
So when you read the SCA judgment,
Yes.
then you'll be entitled to assume that this judgment is only about a just and equitable remedy.
Well, it's also about the review grant, and it makes an important ruling in relation to that review grant on budget. So it declares the contract to be invalid, constitutionally invalid. As a consequence of that review grant, it upholds the review grant, and and then it turns to the just and equitable remedy, and it grants a Gajima Buffalo City type preservation order. That,
Yes, but in all of what it does, it agrees with the High Court 100% except on the just and equitable remedy.
no, it would then have to preserve all those other parts of the order, and in fact it would have to say so. Admittedly, it would have helped if it had said so in so many words. But the fact is it zeroes in on this one grant. It ignores everything else, and there was, the Zeal's case was that the High Court had erred in almost every aspect of those findings. The court, I would submit, can't be read to preserve what the High Court was saying in relation to that. Yes, it sets aside the decision, and I think, sorry, it sets aside the order of the High Court. I think it can, I think it is safely said that it would have preserved aspects of it, and said that only in this limited aspect do we substitute it. For its own reasons, and it was that sole reason, that sole review grant, is our submission, is what occurred there. And admittedly, Justice Colopin, it would have helped to say so in so many words, but it is implicit, we submit.
Okay, let's move to another issue, and this is the issue of a just and equitable remedy.
Yes.
So the cases tell us in broad terms that an innocent party is entitled to be paid for the services that it renders.
Yes.
Words to that effect. And it does so also on the basis that where a payment is made in terms of a contract that's deemed to be invalid, there's understandably a greater public interest in payments that must flow from such an invalid agreement, and public scrutiny is under those circumstances justifiable. Now, if I understand the model that Zeal had in place, it contracted with service providers across the country in the healthcare sector, and that appears from its founding affidavit. And what would then happen is that military veterans who were in need of such services presumably would be told who are these service providers, and they would present themselves, service would be provided for them, they would not pay for the service,
Yes.
and the service provider would submit
Yes.
an account to Zeal, and Zeal would pay them, correct?
Yes.
We don't know what that amount is, and that's not relevant for now. But those were independent service providers,
Yes.
not employed by Zeal, because if Zeal had the authority to say to them in July, well, if you continue providing services, then you must be paid in cash for it, would suggest that.
Yes.
And so, apart from any other costs, Zeal would pay the service provider
Yes.
a fee based on the number of clients that were serviced by a particular practitioner.
Correct. Yes.
So what we have here before us, certainly in respect of the month of June 2015, is that 1,155 people
Yes.
would have presented themselves to healthcare professionals. Those healthcare professionals would have seen to them and would have submitted 1,155 invoices to Zeal.
Yes.
Zeal, as it was entitled to in terms of the contract, submitted an invoice for 14,346 veterans.
Yes.
That's how the invoice was quantified at 365.48 per veteran and came to 5.2 million. Now, I understand that Zeal explains in its papers the different models of costing that it,
Yes.
that it offered to the department, correct? And they were, one was a fee-based model, the other was a capitation model, and the third model was a combination of the two, a capitation with a fee-based. but it was Zeal's recommendation to the department that they go for the capitation model.
Yes.
And Zeal's motivation in advancing that model was that it fixed costs on a predictable basis, that you knew what you were in for.
Yes.
And the department went along with that. I'm not suggesting that there was anything untoward about that, and contractual freedom would allow the parties to do precisely that. But I want to put to you that when the court looks at a just and equitable remedy in respect of a contract that's been declared to be unconstitutional and invalid, it is not obliged to look at that. It may do so, but it's not obliged to look at, to consider itself bound, in a sense, by what the parties had contractually agreed upon in a contract that is no longer valid. Otherwise, it would unduly temper the court's powers in crafting a just and equitable remedy if it was obliged to confine itself to the model the parties had agreed upon. I'm not suggesting that it's irrelevant, but it's not dispositive. You agree?
No, just with respect, no.
Are you shaking your head affirmatively? Well, it almost reminds me
No,
of
no,
one.
sorry.
Okay.
I'm accepting, I'm listening to what you say, but I'm going to argue against it and push back against that conception. First of all, as regards the logic of the rider, the Gajima, the Buffalo City rider, the logic of those is that the contract is preserved. And that's what we say is just and equal, and that's what should remain in this place. If the court is now, as it considers itself at large, and is now considering whether, well, instead of a rider, should we try to ascertain or give some sort of method of determining exactly how much it is that Zeal Health has lost in this kind of instance, I would submit that one must bear in mind the nature of this contract. It's a risk contract. It's almost a form of insurance. The department, and why Zeal proposed it to the department, and why the department accepted this model of capitation, is that it provides a managed healthcare service for which the department knows exactly how much it pays. Zeal Health bears the risk that more veterans will turn up and demand more expensive services than is catered for by the price, by the contract price. It takes a view as to, well, what's the likely uptake of this by the beneficiary population? How many will come? We think not so many in the first month, many more will come once everyone gets to hear about it, until eventually the service stabilizes. The crucial thing about it is that it's a risk allocation. Zeal Health bears a risk that it's going to be overwhelmed by a whole number of veterans who are going to demand services well in excess of the department price, and it's stuck with that bill. The department is not. It's a form of insurance.
I'm not sure that emerges from the papers, but
it's in the nature of a capitation type contract. And it doesn't emerge from the papers, Justice Colopin, with respect, because the department has never brought this up. This is not the basis on which it has defended this case. It doesn't defend the case in saying, well, it's not right that you get all of this money. That's an invention for purposes of this court.
I accept that, Mr. Curry, but you would accept that in looking at a just and equitable remedy,
yes,
the court's not bound by, in a sense,
it has
the fixed positions of the parties. I mean, Ms. Ellis takes the view that it's out-of-pocket expenses, which might be characterized as a fixed position, and Zeal takes the view that it's entitled to its full invoice amount.
Justice Colopin, if the court considers itself at large and it wants to perform that kind of exercise, it's going to struggle to do so in the absence of facts, precisely because of the way the matter has reached you and the way in which it has been presented.
I'm not saying this court should quantify it.
Yes.
But this court can set out the framework,
yes,
for how just and equitable remedy is to be effective.
Yes,
As
there are
in many other cases.
Yes, it could. But there are insufficient facts at the moment. And I would submit that justice and equity, simply on a consideration of what the nature of this contract is. It's no defense to somebody who's, to an insurance provider, a contract of insurance over 12 months to say, well, we never claimed, so therefore you guys can't actually have the full amount of the premium for the full period of the period. The fact is that Zeal Health assumed the risk, and in addition to simply treating veterans who turn up, it has to establish a network. It has considerable costs in establishing this whole system, setting up this whole network in the first place. It has the costs of call centers. This is itemized, I think, and is dealt with in the papers.
But that network had been set up before June, correct?
A big part.
Network had been set up in part before June when it provided services in,
Yes, it had to set it up in advance, yes.
and it did so not in the knowledge that it would get this contract, not so? Because at that stage it was
I
on an
think-
interim contract.
No, I think. No, I suppose not. It would, not in expectation, no. It would have to do so on the fly once it gets the contract.
The only point I make, Mr. Curry, is that it simply seems to me that from a just and equitable point of view and from a public scrutiny point of view, notwithstanding what the parties may have agreed upon, but ultimately it's what is unfolded. And in terms of the notion that a party should be paid for the services that it provided, then what we have here is a significant disparity in terms of those services and what is paid for, notwithstanding what you may say was the risk, etc., because it may be argued that that risk didn't materialize in those
No,
3
the
months
risk
if
did
one
not,
has regard
yes.
to those numbers.
No. Nevertheless, the assumption of the risk is something that you're asking a contractual private sector service provider to undertake. And I suppose my conceptual or principal difference between, with you, Justice Colopin, would be to say that it's just and equitable to say that a contractual service provider who in good faith tenders services on this basis should then not be entitled to be able to claim for the services actually provided on the basis contracted for. I think justice and equity requires that the contract is upheld and that the contract is, you get the benefit of your contract. That's our conceptual distinction.
Sure. I hear that, and I would think a court's obligation might extend beyond that, but maybe we could leave it at that. Thank you.
Mr. Curry, can I just get clarity on the interim contract? The High Court set it aside.
Yeah.
The SCA, on the face of the order, set aside the whole of the High Court order and replaced it with
Yes.
a limited declaration relating to the main contract.
Yes.
Does anything now turn on this? Your client was paid for, was it March and April? And then I think the budget was depleted at some stage. It has been paid.
Yes.
Is it accepted now that the interim contract has not been set aside?
We submitted in the SCA, and we argued that this was also in the, and it's in these papers, it's also in the High Court, that the interim contract has no bearing. It's a completely separate contract. It's a contract for services, for fee for services. Zeal Health performed the services until the budget ran out. It was paid. It's got nothing to do with this contract.
No, I appreciate it's got nothing to do with this contract, but the High Court's nevertheless
Yes, it did.
set it aside.
Yes.
And the SCA's reasoning doesn't address why that part of the High Court's order was incorrect.
No, it doesn't expressly do so. No.
Well, maybe Ms. Ellis can tell us in reply, but I'd just like to know that we can treat that part of the case as irrelevant. Your client's been paid and the department has not sought to
And
recover.
I know that Ms.
payment.
Ellis will say that the interim contract is terribly important and that it makes all the difference in the world. Our submission, and it's set out in the papers, is that the interim contract is completely irrelevant. It was one thing and it was dealt with.
Well, it seems to me that at least on its face, the SCA order set aside the whole of the High Court order and substituted it with a different order,
Yes,
which didn't set aside the interim contract.
yes,
And there's no appeal before us
yes.
against that, assuming it is an issue.
It didn't deal with it expressly. It is implicit in that substitution.
Whether it clearly didn't reason, it
Yes.
contains no reasoning on that
No.
order,
Yes,
doesn't, seems to me inevitably to set aside everything other than the declaration relating to the main contract.
with respect, I would agree, Justice Roger.
And
Yes,
if there was to be an attack that was done without
Yes.
properly explaining,
yes,
then there should have been an application for leave to appeal from the department against it
yes.
in this court.
With respect, yes.
Just to go back to the distinction between the 3 months for which your client invoiced, and you say in itself it would be very helpful to your client, at least if that was preserved, but you argue that the full contractual position should be preserved. Do you accept that the fundamental distinction between cases like Kajima and Buffalo City and Pamela and this case is that in those cases, the actual services contemplated by the invalid contract were delivered throughout the period for which accrued rights were preserved.
Yes.
And in fact, the review proceedings were brought very late. This case is fundamentally different in that while your client tended to render the services and may legitimately complain at the level of contract that it wasn't allowed to do so, the fact is that it didn't end up rendering the services. In considering what is just and equitable, is that not a fundamental difference where the court, if this court is at large to reassess what the SCA did, to say in respect of the 3 months, or we must consider whether we will preserve the accrued rights, or as Justice Colopin has raised, perhaps set out some other framework which might cover all expenses and allow some profit, but not necessarily at the contractual rate. I must say, prima facie, I'm in favour of the contractual rate, but there will be some such order made in respect of those 3 months. And in respect of the balance, which includes expenses that your client incurred in September and October in providing the emergency services, to say there we must limit your client to out-of-pocket expenses.
Yes.
Otherwise, how would this court, in its reasoning, justify treating this as on all fours with cases like Kajima, where in this case the services weren't as a fact rendered?
I don't want to repeat my earlier submission I made in answer to Justice Matopo, but our understanding of the logic and principle of the preservation of accrued rights is that the rights should be preserved, the contractual rights. And that the signal that sends is that service providers can contract with the state in some sort of confidence that it's going to be treated as more or less a normal kind of contractual situation.
Mr. Curry, just try and speak to the mic.
Oh, sorry, apologies.
Yeah.
It's going to be treated as an ordinary contractual matter if it's just and equitable to preserve your contractual rights. That's which we would say that Kajima, yes, there was that distinction that the contracts were almost, I think, as I recall, fully performed, but that it should in principle make no difference here. Yes.
One will have to go back to the cases to see whether that was explicitly teased out in any form of dictum. But even if it wasn't, that was the factual scenario in which the court was considering just an equitable relief. Yes, there was something else I was going to raise, and it temporarily has gone out of my mind, so I'd better perhaps turn off my mic.
Thank you.
Okay. Mr. Curry, that's it for you.
Thank you, Justices.
I have now remembered what I wanted to say. If we were in this case to find in your favour and preserve all the agreements, we would effectively be saying that in every case where a government tender and resultant contract are declared constitutionally invalid, the innocent contractor must get all its accrued rights, because typically these contracts would run for, well, say, 3 years, 2 years, maybe 4 years, sometimes 5 years. The declaration, in the nature of things, the review will be instituted at some stage. It will take some time to get to a high court judgment, then there's an appeal.
Yes.
It's only finalized, inevitably, after the contractual period has run its course. And if you can say, well, that you must now preserve accrued rights, it will mean that all accrued rights under these invalid contracts will always be preserved for innocent contractors. And that doesn't seem, is that an outcome you would support?
Justice Rogers, as I understand the jurisprudence of this court, these types of just and equitable orders simply don't establish those kinds of general principles. So it's always going to be fact dependent, and it's always going to depend on justice and equity. But I would submit that as a aspect or a principle of justice and equity, that one shouldn't consider the fact that a contracting party was interrupted or stopped in its performance halfway through or early on in the contract as being an inevitably relevant factor, a factor that always confines you to being able to claim only your contractual rights up to the point of interruption, as it were. That I think, is the distinction. So it wouldn't establish, and I don't, apologies.
You wouldn't surely say that it's not a relevant factor. You'd say it shouldn't be elevated to a decisive factor.
Yes, thank you. Yeah, that is what I mean, yes.
Thank you.
Thank you.
Thank you, Mr. Curry. Ms. Ellis?
As the court pleases. I want to address the court only on two issues. I think it's important to indicate to the court. Mr. Curry made the submission that the invoices were never disputed by the department, but that is not correct. If I may refer the court to volume 1 on page 33, that is Annexure FA 14. It is a letter that the acting chief financial officer of the DMV wrote to Zeal Health, the chief executive officer of Zeal Health, immediately after receipt of the first invoice. And if I may read it into the record, paragraph 2 starts, it says, the Department of Military Veterans received a taxed invoice dated 6 July 2015 from Zeal Health Innovations for services allegedly rendered to 14,346 military veterans. Paragraph 3, you are accordingly requested to provide DMV with a copy of the signed contract that you entered into. That was in dispute. That was in dispute already in July, that there was, whether there was a valid contract or not. Paragraph 4, further that you are also requested to provide a detailed taxed invoice stipulating the patient's particulars, the medical services rendered, and by whom. The amount in the tax invoice must be broken down in accordance therewith. We await your urgent response. Needless to say, there was no response from Zeal in that regard. The only response that Zeal eventually, or together with the invoice, had in that regard is to attach that health report compiled by Zeal itself, indicating that in July it only served, I think it was 1,108 patients and a certain number of patients for psychiatrical. That was the only report or reaction to that request or that concern. So it's not correct to say that the invoices were never disputed. The same principle applied to the second invoice. The third invoice, the August invoice, was only claimed for by Zeal Health in the amended notice of motion. So the health report by Zeal Health was only provided together with that invoice. So that is not correct. The second issue is, that is in order to address the concern raised by Justice Rogers pertaining to the interim tender. It was indeed correct. The interim tender was also plagued by irregularities, and the High Court, in terms of the irregularities in the procurement process of the interim tender, set it aside. However, in that regard, the applicants issued the quotation on a fee for services basis, and there was the budget of 500,000 was stipulated on the quotation in respect of the 3-month period. However, as a result of the 2 invoices that were submitted by Zeal Health in respect of the interim tender, which both invoices was subsequently vetted by the department and resubmitted to Zeal Health, who then submitted reduced invoices, was paid in full, and when the Supreme Court of Appeal decided that as a result of the fact that Zeal was paid in full, there is no purpose in confirming the setting aside or declare the interim tender invalid, hence they excluded that from the order. Applicants did not deem it necessary to take that matter on appeal to this court. That is the reason why it was not appealed. However, the interim tender, as I indicated, was the quotation was asked for on a fee for service basis, and the fee for service that Zeal quoted in that matter, in that quotation, was the same fee, the same premium of 364 Rand, I think, 80 cents, the same as the final tender, but the fee for services was only tendered or quoted for 1,300 patients. But that is the reason why the interim tender and the part of the SCA order regarding that was not appealed. The applicants did not deem it as vital as the fact that the order made by the court preserving the unlawful contract is the pertinent order to request this court to correct on appeal. Those are my submissions in reply.
Ms. Ellis, just to round up, is it your argument that the 3 invoices were disputed and continue to be disputed? And because they were disputed and continue to be disputed, the out-of-pocket expenses that may have accrued in September and October, what do we do about it?
Well, and Justice Matobo, that is exactly the problem that the applicants have, that it was an allegation made by Zeal Health on the papers without providing any invoices or proof that any service provider was paid or that any military veteran made use of the services. So there was no factual proof attached to the papers. It was merely an allegation made, and as I said, that the amended notice of motion that Zeal Health submitted in the High Court, if I remember correctly, it was also done in April 2018, where the 3rd invoice was added to the relief, the specific performance claim by Zeal Health. There was no mention of any services rendered by Zeal or claimed for in the amended notice in 2018 in respect of September and October. The department also never received any invoices or any indication that services were continued to be rendered by Zeal after 12 August 2015, except, as I already indicated, that the 3rd invoice, the August invoice, was rendered in full in terms of the contract as if services were rendered for the full month of August, which it clearly was not on Zeal's own version.
Okay, thank you.
So, sorry, Ms. Ellis, I just need to clarify something. I worked on the basis that it was not in dispute that the capitation model was one that the parties agreed to as forming basis on which invoicing would take place. I hear you say that the invoices were disputed, but are you saying that the question of which model a Because you say the interim contract was based on services, not on a
Fee for services, yes.
right, but then the contract that is the subject of this dispute, that wasn't based on fee for services, was it?
The final tender?
Yes.
No, it was based on a capitated fee
Okay, no,
basis,
that-
which was one of the grounds raised in the review.
sure, I
Yes.
hear that, but I just
So-
want to clarify that you queried the invoices, but you accept that the contract was based on a capitation model, which you queried in the review.
Yes,
Yeah, okay.
yes, because the capitated fee basis, the total amount on the capitated fee basis amounts to 198 million rand. And the allowed budget for the entire 3-year contract was only 31 odd million.
Well, I just find it a bit strange then that you query that at page 33, where you ask for details of patient seen. But you say that the capitation model was the one that you agreed upon.
I beg your pardon, Justice Collipin.
If the capitation model is the one you agreed upon, then that model is based on 14,436 people, correct? Irrespective of how many people you see.
Yeah, but as I stated in my address, my earlier address, that there was no tender, it was an open tender. The agreement was that it should have been on a fee-for-service basis, which it was not. So the capitated fee basis was approved and accepted by the various bid committees who evaluated and adjudicated on the tender, which we have indicated was irregular. The process was not followed as agreed upon or as the budget allowed for it.
Okay. Because
So to say that we did not dispute the capitated fee, Justice Collipin, or the applicants did not dispute it, is with all due respect incorrect.
Yeah. What compounds it, though, is that the applicants in their founding affidavit said that the query that you raised in page 33 took them by surprise because they relied on the capitation model. That's what they say in their founding affidavit. And then in the answering affidavit, that's not really dealt with specifically. It just says there's a general denial, and nothing is said specifically in the answering affidavit that this model that they put up in paragraph 34, which is a capitation model, was not the model agreed upon. So
Yep.
on the pleading, certainly
If I recall
that
correctly,
doesn't seem to be placed in dispute, as you say.
yeah, if I recall correctly, at the stage when the answering affidavit was drafted, the department did not have access to all the relevant documentation. So the capitated fee or the fee, I beg your pardon, I'm thinking in Afrikaans now, and I can't think about the English word. The price of the tender was not available at that stage. Once it became available, in the supplementary founding affidavit, the applicants dealt with that, specifically with the fact that the capitated fee basis was not within was not what they intended the tender to be based on. So it is in dispute.
Okay, we'll look at that, whether what they intended and what they ultimately agreed upon here. But
Thank you very much, Ms. Ellis. Judgment is reserved. Court
As-
adjourns.
As the court pleases.